Well, all the talk today, aside from the budget, of course, is the National Anti-Corruption Commission. Details have been outlined by Labor. The coalition look likely to support them, but we will see the crossbench is pushing for what they say is the version that gets the most sunlight in, if you like. Joining me is Legal Affairs contributor for The Australian, Chris Merritt, who also has strong views. Thanks very much for your time. I guess just starting with the point of most contention, so would there be public hearings in this federal ICAC, if we can call it that? It would only happen in exceptional circumstances, so a pretty conservative view on that. When would those exceptional circumstances be, do you think?
Well, I disagree with the premise. I don't think it's a conservative circumstance at all. I think what's happened is that I've only had a look at the bill this morning. It's 250 pages and the explanatory memorandum is another 300 and something. But I've had a look at the circumstances in which public hearings can be held or called, and what the Commonwealth has in fact done is stripped away one of the important checks on abuse of power that is actually part of the New South Wales ICAC Act. If you're going to have a public hearing in New South Wales, the Chief Commissioner must have the support of at least one other Commissioner. The bill that's been presented this morning by the Attorney General, Mr Dreyfus, doesn't have that check. It's a discretionary matter for the Commissioner. And that again is watering down the arrangements that are currently in the law in New South Wales. In New South Wales, the Commission must consider a number of factors, and federally, some of those factors are present, but they're discretionary. The Commission doesn't have to, or the Chief Commissioner doesn't have to consider them. Now the whole point of being wary about holding public hearings is to avoid damaging people without just cause, damaging innocent people. And remember, this is not part of the justice system. The National Anti-Corruption Commission is not a court, it's not part of the justice system, it's got nothing to do with enforcing the law and holding wrongdoers to account. It's a commission of inquiry. So by holding a public hearing, and this is the experience in New South Wales, it can in fact delay justice. This happened with Eddie Obeid. When Mr Obeid was eventually convicted in a court of law, it was over matters that took place 14 years in the past. It had been under consideration after ICAC had considered its decision for, I think it was 6 years for the DPP, because there was an inconsistency between what the rules that apply in ICAC and the rules that apply in a court. So if the point here is to be cautious about holding public hearings and to consider exceptional circumstances, it would be nice if those exceptional circumstances were spelled out in the bill that's now before Parliament. They're not. If you go to the definitions section, it's just not there. So it's completely up to the Commissioner in his discretion as to whether he will think that there are exceptional circumstances, and that makes it impossible or very difficult to challenge.
That's an interesting point on that detail. So I think that will be something I'm sure will get more attention. So perhaps easier to hold compared to New South Wales, depending, of course, on what the Commissioner decides. So at the very least, bigger power to the Commissioner. You mentioned as well the issue of having public hearings, and this is what's spoken about a lot. A public hearing, at the end of that, there might not be a finding of corruption, but the person involved, their career's gone. I suppose what's interesting about this is that when we see politicians normally being forced to resign, it's quite often not over, almost never over something that's actually illegal, but just something that's viewed as them not being above board. Is it not possible for that to happen at an integrity or anti-corruption hearing, that yes, there isn't at the end a total corruption, or it might not be a criminal standard, but still society judges what they did not to be above board?
Well, that's a political matter. This is another point. Normally, politicians in our system the government is sovereign, the Parliament is sovereign, and they make their own decisions and police themselves. And now the effect of this tribunal is to set up a separate mechanism that will effectively pass judgment on what was previously a sovereign House of Parliament. The conduct of the members. It's a new world. We're opening a door on a new system of we know nothing about it or how it's going to work, and we're handing immense power to the new commissioner. So I really hope that the new commissioner knows how to do his job.
Okay, you've taken issue with the fact that this corruption commission, anti-corruption commission, would deal with serious or systemic corruption, not serious and systemic corruption. I mean, if corruption is serious enough in a one-off, isn't it still worth pursuing?
I agree. In fact, I would argue strongly that the focus should be focused strongly on serious and systemic corruption, not serious or systemic corruption. If we're talking about making a choice between chasing serious misconduct and conduct that is not serious, I know which one I'd go for. It'd be serious misconduct all the time. I can't understand why why that distinction is being made. All it does is
So
make
sorry,
it
to
possible.
just to clarify, are you saying you'd be worried if it was chasing something that was systemic but not particularly serious, rather than the other way around?
Yes, I mean,
Right, okay.
why should a commission, a high-priced commission worth $200 and something million over 4 years, be bothered chasing public servants who steal notebooks or paper from the office? I mean, I think we've got other ways of dealing with that.
But it should be clarified to just say, if it just says serious, then that's it. That's the key word for you.
Yes, serious is the key.
Okay.
There shouldn't be a distinction. The Commission should not have a choice about whether it's going to chase serious matters or systemic matters. It should only chase serious matters, and if that is systemic, well and good.
Okay, I perhaps misconstrued what you wrote, but I'm glad we've cleared that up. So serious is the key word there. Finally on this as well, you've written to really dumb this down, that essentially you see this type of commission as the could test versus higher standards, whether it be in the criminal system or elsewhere, as the constitutes, as in it did happen test. Can you just note that me and many of my viewers are not legal minds? Can you just sort of explain what you mean by that?
What's happened is that the Commonwealth has effectively copied the test for corruption out of the New South Wales ICAC Act, and that test has been criticised in a report to the New South Wales Parliament on this ground. It covers not merely serious misconduct that has been found, it covers the possibility that serious misconduct may have taken place. It's speculative. If you're going to declare someone corrupt, it should be hard and fast. There should be, at the very least, a factual base, not a speculative base for their conduct. There needs to be some tangible outcome rather than a possibility that something might have happened. It's simply not good enough. If you're going to have a Commonwealth tribunal funded to this amount of money, holding public hearings, the least you can expect is that it would apply a rigorous standard, not a speculative standard. That's my concern.
All right, well, you've taken us through. It's great to have a legal mind like yours looking at this. There's a lot of, obviously, detail to get through, which you're already getting through. I'm sure there'll be more, and we'll talk to you in the coming weeks. There'll be more debate about this, I'm sure, as well. Chris Merritt, thanks very much for your time.
Quite okay.